So welcome to managing anaphylaxis and asthma in schools and nurseries. What we're going to have a look at initially is the objectives of the course, and then we're going to have a look at some of the legal aspects in relation to it. So the course itself is allocated 2 hours to go through the e-learning videos and then a knowledge check at the end of it, and then you download your certificate. The course objectives is by the end of the course, delegates will be able to explain the requirements under care planning and duty of care concerning young people in the education and nursery sectors with anaphylaxis and/or asthma. Secondly, to explain examples of when children have died in schools or nurseries and the recommendations which came from those court cases. Explain what anaphylaxis and asthma are. Explain the relevant guidance for schools and nurseries to adopt, and explain the legal and regulatory requirements concerning the medication for both conditions. So we're going to be looking through the legal issues, the procedural issues, the practical application, and also issues around the emergency planning. So looking at where it sits in the hierarchy of things in relation to first aid. So first aid, when we're looking at the first aid arena, it's about initial helping behaviours when a person is unexpectedly taken ill or injured. It's standard training, it's generic training. But if you've got a child who you've got a duty of care for, and then you've got reason to believe that they have a life and death medical issues such as anaphylaxis or asthma, then it's no longer looking at the issue of first aid, we're looking at the duty of care model. And as a duty of care model, you need to make reasonable adjustments and also look at the care planning aspects, the risk assessment, and ensure that there's suitable and sufficient staff constantly on duty who know what to do in relation to that particular child. Then in between first aids and the duty of care models, we've got the medical emergency. Now, if, for example, anyone goes into an anaphylactic emergency event, that is a medical emergency, and any member of staff can assist. However, it would be investigated in relation to the fact that you should have suitable and sufficient staff on duty, readily available, with the medication also readily available in order to assist that person. So again, looking at the issues of first aid, the emphasis with first aid is the assessment and the triage decision. So as soon as you've got any inclination that a person has gone into an anaphylactic event, the assessment is over with. Your triage decision is 999. Then you're going to go into medical emergency phase until the emergency response of the paramedics can arrive. Now, if we're looking at the hierarchy of the law, ultimately at the top here is the human rights and the entitlements. So for example, Article 2, the right to life and your positive obligation to safeguard a child in your care and to prevent their death. Then examples from the Acts of Parliament, which sit under there, we've got the issues around the Health and Safety at Work Act. So you have legal obligations under the Health and Safety at Work Act to safeguard any person affected by your business, so that covers the children. So that will include things like sufficient risk assessment, sufficient planning and preparation for that child. We've also then got to think about, in relation to Acts of Parliament, medication issues. So during the course, we'll look at the issues around the medication, because epinephrine, which is the contents of the likes of your EpiPen or your Jex pen, is a prescription only medication. Therefore, it's a controlled medication stroke drug. And there's issues around the safety of that medication, and that it shouldn't just be left out in staff rooms, etc., overnight when the business is shut. Looking at the regulations, we've got some recent changes in regulations in relation to the adrenaline, particularly for schools and nurseries. Then looking at guidance, so the statutory and non-statutory guidance will introduce you to the likes of the Department for Education, recent guidance, and Department for Health. Then looking down locally then at your policy and procedures, but we'll also take into account here national guidance in relation to this, so such as from the unions, and then ultimately around your training. So we're going to dip into things like the Department for Education advice, Department for Health, union guidance, guidance from your insurance companies, the NICE guidelines, so the National Institute for Health and Care Excellence, and we'll also be looking at things like the Faculty of Forensic and Legal Medicine and the Joint Royal College's Ambulance Liaison Committee guidelines. So first then, let's have a look at some of the legal side of this, and let's see what's happened over the years and how the courts have viewed this. So the first case I want to bring to your attention is if we jump back in time to 2002. So here we've got a nursery who was convicted and fined £60,000 after the death in 2002. They were convicted in October of 2003. So we've got a 5-month child here, Thomas Egan. He was fed dairy products on the 11th of April in 2002, despite having a severe allergy to milk. He suffered a severe reaction and died of a heart attack within minutes of being given a dairy-based breakfast cereal at Jigsaw Day Nursery in Milton Keynes. The nursery admitted a criminal liability under the Health and Safety at Work Act failings. The inquest found that Thomas's death had been accidental death contributed to by neglect. The Crown Court was informed that the nursery had committed 11 failings in the care and treatment of Thomas. Thomas Egan died through an anaphylactic reaction to being given milk. In addition, there were no first aiders on duty and no emergency procedures in place. The judge stated that his death was preventable and fined the company £60,000 with additional £19,000 for legal costs. Thomas's parents believed the sentence was too lenient, and their view was that Thomas was killed due to failings made by staff. So let's jump forward from 2002 to 2016. So 2016, and the headline in the newspaper is "Mother of Boy Who Died from Allergic Reaction to Dinner Criticises the School." So now we're within a secondary school. So this is a secondary school in East London, and the family say that this school failed their 14-year-old son by not giving him the adrenaline shot. The mother of the boy who died from the allergic reaction to his school dinner has accused staff who failed to give him a potentially life-saving shot of adrenaline of failing in their duty of care. The boy went into anaphylactic shock at Bow School, East London, in November 2016 after suffering a reaction to milk in his lunch. He had a history of severe asthma and food allergies, but staff did not administer his EpiPen, which was kept at school and could have saved him. The coroner returned a narrative conclusion saying the staff saw Nazir's EpiPen and considered using it, but did not. If the EpiPen had been used promptly and Nazir had been administered adrenaline, there is a possibility, but not a probability, that this would have changed the outcome. The inquest heard that Nazir's asthma had been inaccurately listed by the school in his care plan as mild to moderate rather than severe, and there was no mention of an EpiPen or using adrenaline to tackle his allergies. Now that raises an issue there which we always recommend. Plans are never left to one person to write or assess because it's easy, or there's a potential there for things to be missed. There should always, as far as possible, be a panel of people, so a minimum of 2, preferably even 3 or 4. Staff at the school were encouraged to familiarise themselves with pupils' care plans, but often did not unless there was a school excursion. Even the deputy head teacher, who had in the past taught Nazir, did not know about Nazir's food allergies or the fact he had a care plan and allergy action plan. The family said, "We strongly believe that if Nazir's care plan had been completed correctly, if staff had been aware of the care plan, and if it had been followed properly, including administering an EpiPen as soon as possible, that Nazir would be alive today." So we now jump forward a year to a 2017 incident. And here we've got the headline grabbers from the newspaper: "Boy killed after pupil flicked cheese on his neck, screamed, 'I'm going to die.'" And this is in May of 2019. So the coroner's court sat in May of 2019. A schoolboy allergic to dairy who had cheese put down his collar for no reason shouted, "I'm going to die," minutes before he was given an out-of-date EpiPen, an inquest has heard, at William Perkin Church of England School, West London, on the 28th of June 2017. The inquest heard the EpiPen used was an entire year out of date due to an error on a spreadsheet. So the barrister said, "Did you not think a second EpiPen would be a good idea?" Now, again, at the conclusion of the coroner's case, one newspaper extract here on the 10th of May, "Could he have been saved? School of cheese allergy death boy 13 slammed by coroner for having year out of date EpiPen." A coroner has slammed the school at the centre of a boy's cheese allergy death after it used an EpiPen an entire year out of date. Now, one of the things we'll look at in this course is the fact, if you've got medication on site, you have legal obligations to ensure that, for one, the medication is in date. The moment that medication is out of date, it should not be on your site. And it's important that you have robust medication management procedures in order to check this and keep checking it. This mistake should never have occurred. Plus, you should be checking that medication at least once a month, and that's at least once a month, a minimum of monthly. So even if the error happened to start with and the medication came on site which was out of date, it should never be on site for more than a month out of date. Now, the coroner's court produced, what happens at coroner's courts is, if the coroner is of the opinion that future deaths could be prevented, they can produce what's called a Regulation 28 notice, and this then is the Prevention of Future Deaths reports. Now, we're going to give you the link to this actual case so you can read the full report, but I've highlighted here just some of the points that the coroner pulled out of this case. So first off, they said that the pupils at the school had a patchy understanding of allergies, what they were and the consequences of exposure to allergens. Targeted education about this would improve safety. So one thing for you to think about as a school or nursery is, what do you teach other children collectively about risks and management of things like allergies? Because if you've got other children on site who are known to have allergies, then we need to make sure that the site is as safe as possible. The second one here, highlighted in red, is that the school care plan and medical books were not checked or audited. So as I mentioned just before, there's legal obligations when you've got controlled medications on site that you must make monthly checks in relation to that medication and then keep audit sheets for them. So again, you might be interested in our level 1 medication management or the level 2, but it's essential that you've got check-in processes for this. Thirdly, the EpiPen was out of date. There's expiry dates on medication for a reason. The older the medication, the more likelihood that the medication will change in its value. So the content of the medication can change, and that medication can either become ineffective or the compounds can change and become harmful. So it's essential that medication is not used out of date and should not be on site. Allergy action plans are not standardised across hospitals and schools. So again, it's about getting your multi-agency teams together to look at how we can improve those. The allergy action plan drafted by the doctors at the hospital did not find its way to his school. So if you're in a school or nursery, it's about asking for what you need. And because it's a safeguarding issue, so if you've got any information missing, it's no good just saying, well, mum or dad hasn't brought it in. If you've got a child on site with a condition that could end up in being a life and death situation, the only way you can provide safe care to that child is by knowing the details of that condition. So if you haven't got the information from the parent, then from a safeguarding point of view, you need to be contacting the local authority nurses, for example, or raising it with the local authority designated safeguarding leads. There's clearly a need for medical teams to emphasise that 2 EpiPens must be available at all times. The standard now is for every child on your site who's prescribed auto-injectors, so either EpiPen or Jext or any other make, that they have 2 auto-injectors that are prescribed to them on site, readily available for them. We'll also look during this training at the issues now where you as an education sector can obtain additional auto-injectors which are not prescribed to a particular child. Another thing that was brought out was instructions were not communicated effectively as part of the school staff's first aid and EpiPen training. And what you often find with the likes of first aid training is you'll get taught, there's the pen, you take the cap off, there's how you hit it in. But there's a lot more to managing anaphylaxis than just activating and administering the pen. That's just one part of it. So, returning a narrative verdict at the coroner's court, the senior coroner said the boy who had thrown cheese and the one who had passed it to him were oblivious to the potential consequences. It was a childish and thoughtless act, but was not calculated to cause serious harm, she said. However, the coroner laid the blame for 2 contributory factors in the death at the door of the school. She said, most importantly, in terms of the potential to change this outcome, there was a missed opportunity by the school to raise awareness amongst their pupils of the grave nature of his allergies and the care that needed to be taken to avoid his contact with allergens. The coroner also described the school's healthcare provision for him as inadequate, citing an insufficient care plan, the fact that there was only 1 EpiPen in his medical box, although his mother had said he needed 2, and the lack of a robust system for checking medication being in date. The inquest heard that only 1 EpiPen dose had been given to him, which was 11 months out of date. School staff said they would not give him a second EpiPen because they thought a 10-minute gap was necessary between doses, which it isn't. That's a myth that's often there, that people believe they have to wait 10 minutes. Had not been told to do so by the ambulance operator, and he only had 1 EpiPen in his medical box. The coroner said it is impossible to say whether the use of adrenaline that was in date or the administration of a second EpiPen would have changed the outcome, but they would have given him a better chance of survival. A lawyer for the family said the family was considering taking action against the school in light of concerns about the part that the school played in the death. So then we jump forward a few more months to July of 2019, and the BBC News reports that the Health and Safety Executive is now investigating the school concerning possible criminal charges. And the newspaper extract is there for you to see. Now, the coroner said she would be issuing reports on the prevention of future deaths to 9 organisations, including the school, the Department for Education and the Department for Health, in an attempt to guard against similar incidents. His medical cause of death was post-cardiac arrest syndrome, anaphylactic shock, multiple food allergies, and bronchial asthma. There's the link there to the actual Prevention of Future Deaths report if you wish to find it. Now, the executive head teacher of the trust said, "We are deeply sorry that we could not save Karen. We completely accept the coroner's findings about the systems that we had in place at the time and regret that they were not enough." Now, that's looking at some of the criminal liability issues, and the question then to pose you is in relation to, if that's how the courts are looking at these events which have occurred in the likes of 2016, 2017, what happens when the next case occurs in another year, another 2 years? And so it's essential that we know and that we understand what the current best practice is, and also issues around criminal liability, because prosecutions under, for example, either health and safety offences or the likes of manslaughter are known as offences of strict liability. Therefore, you do not have to prove that there was any criminal intent. All that has to be proved is either through acts or omissions, the person died, or the person was injured if it's the health and safety issues. So just because somebody has no criminal intent to cause a child harm does not mean that either the business or the individuals can evade liability.